Good afternoon. Welcome to our Tuesday webinar. We are here with Matt Grumbling. Hi, Matt.
Hi, how you doing, Julie?
Great. So we are right smack dab in the middle of a copyright series. And today we are going to be, or Matt is going to be talking to us about copyright strategy and how to fit copyright into your overall IP strategy. So for any of you really needing this information, this should be really good.
Okay, I'm ready to start here.
All right, well, take it away.
All righty. So again, my name is Matt Grumbling. That's my name up here at the top. My email address, matt@ntiplaw.com. It's my cell number. Feel free to text message me if you like. Just let me know who you are if you do that, so that I'll know who I'm getting a text message from. You can check our website out at www.ntiplaw.com, and that's short for nwintarbetlaw.com. Today's topic is copyright strategy, and this is for educational purposes only. I'm not your lawyer, but this is an opportunity to kind of share some knowledge about things that you should take into account when you're putting together your overall intellectual property strategy. This is how to fit copyright into that bigger overall intellectual property strategy, or as we say, IP strategy. So let me get started here. Today's topics are sort of it's kind of simple in the sense we're going to break it down into two big topics. One is the conceptual framework, categories of copyright protection and what can and can't be copyrighted, things like fair use, and then secondly, we're going to integrate copyrights and patents and trademarks and trade secrets into a cohesive strategy with a kind of an emphasis on copyrights. How do copyrights fit into this whole thing? What we're going to do here to start off with this conceptual framework is kind of review what the different types of IP are that are available. I mean, at this stage, I've done a series on patents. I've done a series on trademarks. So now we're in the middle of copyrights. How do we start to integrate all of these things together? And one thing we need to do is remind ourselves, well, what types of intellectual property are there, and what kind of characteristics do they have? So copyrights, they cover original works of authorship. Now, what does that mean? Original means that it's an independent creation, that is, you didn't copy it from somebody else. And independent creation is a perfect defense to copyright infringement. And I say it's a perfect defense. It's hard to prove a negative. It's hard to prove that you didn't copy something, but in order to prove that you have infringed, the copyright holder has to prove that you copied. Conversely, if you're the copyright owner, you have to prove that the other side has copied your work. That can be done in a number of different ways. Most commonly, it's done by proving that they had access to the work and that there's a considerable amount of similarity between the works. So it's more by inference than an actual proof of copying. Although there are times when a proof of copying is possible. Maybe there's some sort of a watermark or something that's been embedded in, say, a digital download, where it's super easy to show that there's, or it just, let's say it is a digital download of say, a copyrighted code or copyrighted video or audio or something like that, and it's pretty blatantly obvious that there was out and out copying. It gets a little bit more complicated when you're trying to prove, say, copying of a musical, say, a musical arrangement or something like that. We talked about that a couple weeks ago when we were talking about, say the Led Zeppelin case, where there was the accusation that they copied part of Stairway to Heaven, and they had to show that there was the plaintiffs in that case had to show that there was a significant similarity between the works, and that the members of Led Zeppelin had access to it at some point. And where that case fell apart for them really was where it was because of the limitations of how they could prove similarity. The jury just wasn't able to maybe fully appreciate the similarities between the two works. So, so independent creation is a defense to copyright infringement, and there has to be some basic level of creativity involved. So copyrights do not cover phone books or other, other types of obvious, alphabetical listings of information. Just basically the underlying information is not copyrightable. You can, every author has the freedom to express an idea independently. And so there has to, in order for there to be a copyright involved there has to be some minimal level of creativity in how it's presented. So let's say Albert Einstein, picking on my favorite wild-haired scientist, he comes up with a theory of relativity. He expresses it as E equals mc squared. That by itself is an idea. It's more of a mathematical formula, and it isn't covered by copyright. But in a journal article that he writes or that he wrote and published, let's say in the in a physics journal of some sort, would be covered by copyright because it's an expression of the idea and it's his explanation, and there's some creativity involved in there. Patents cover machines, manufacturers, processes, and compositions of matter, and there has to be an independent creation is not a defense to patent infringement. Basically, what we have in the United States now is a race to the patent office. The first one to file gets to get the patent. And there's some exceptions. The first person who is an inventor gets to file and get the patent. Trade secrets. There's not much more to say about trade secrets than that they're secrets. If it's not secret, it's not a trade secret. Now, trade secrets can cover things that are covered by copyrights. It's something that, let's say a copyrighted work that has not yet been published remains a trade secret. But trade secret covers a lot more because it can cover lists. It can cover things in which there is no minimal level of creativity, and yet it is a secret. So so there can be some overlap between trade secret and patents. Before you file, let's say, your patent on a novel process, it is covered by trade secret, presuming that you actually have kept it secret. Let's see, and basically it's anything that isn't publicly known. Trademarks indicate a source of goods or services. That's all they do. It's a very powerful thing that they do, because trademarks, oftentimes you've invested a lot of money into developing a good trademark that's strongly associated with your good or service. There's a lot of goodwill that goes along with that. There are customer expectations. A lot of times, if you're thought of well by your customers, you can charge a premium for your goods or services because they trust you and because they value your good or service. And if somebody violates that by copying your trademark and slapping it on whatever nasty copy they've made, you can go after them. And basically, it's seen as a way of protecting the public from unscrupulous people who try to pass off their good or their service as yours. So let's talk about the term of protection for these different types of intellectual property. For copyrights, it's the author's life plus 70 years or 100 years from the date of creation. And what differentiates these again is this is what applies in most cases. We'll just call it the default condition. This applies where there's a work for hire, where a company has hired somebody either as an employee or as an independent contractor. But the purpose of hiring that individual is to create this thing that will be owned in the first instance by the company. That thing that work for hire versus the sort of the default condition is sort of important. So, generally speaking, for instance, a corporation like Disney Corporation will create things and they will do it as a work for hire. So they get 100 years from the date of creation, not 100 years from the date of publication. The creation, there might be quite a bit of time between the creation and publication. For instance, if you're making an animated series or an animated film, you may prep everything. You may start prepping, and you may actually do all of the animation in, let's say, 2021. But then you go through post-production, and that it might not actually end up being distributed for another 2 or 3 or 5 years, perhaps. Well, it was the date that it was created that governs this 100 years. So it takes you 5 years in post-production to distribute it. Then the copyright effectively lasts for 95 years. Now, for patents, you get 20 years from the first U.S. filing. I'm not going to go into a lot of details on that, but there are ways to get some upward adjustments to that number. So 20 is a baseline. There are exceptions to that, but generally speaking, it's 20 years from U.S. filing. Trade secrets are perpetual as long as they're maintained as secret. As soon as they are, their secret nature is broken, they are no longer trade secrets. So if you publish something that you accidentally publish something you didn't mean to publish, it's no longer a trade secret. It's now in the public domain, unless you've already taken the steps necessary to maybe, if it's protectable by copyright, to mark it as a copyright, or if it's patentable, to file a patent application. Trademarks are also perpetual, but they have to be continually used in commerce as a source of goods or services. And you also have to pay there are trademark maintenance fees. It's one of the great things about trade secrets is that they are, for all intents and purposes, free. Whatever it costs you to keep things secret, your firewall or whatever it is, that's all it really costs you. So let's talk about how various types of intellectual property are created. Copyrights are created when an original work of authorship is fixed in a tangible medium. So if you're writing a book, as soon as you type the words into your computer or write them out on a piece of paper, if you're old school, or type them on a piece of paper if you're somewhere in the middle of between there, that's how your copyright is created. Now there's also registration, but that's a separate thing. Patents are created by filing an application with the U.S. Patent and Trademark Office. Trade secrets are created by maintaining a trade secret. Trademarks are created by using it. Okay, well, I said perpetual. Trademarks are created by basically using the trademark on an article of commerce to indicate source. Okay. So how do you lose intellectual property? Copyrights are lost basically by expiration of the copyright term. Now, in pre-1978, there was a requirement that copyright registrations be renewed, but that's no longer a requirement. Patents can be lost by expiration of the patent term, which is 20 years, failure to pay periodic maintenance fees, which are due at 4, 8, and 12 years, or cancellation. Trade secrets, basically by publication, as long as they're no longer secret, or as long as they're secret, they're perpetual and they're not lost. But as long as it becomes no longer secret, then what does that mean? Well, it's divulged to somebody who isn't under an obligation to keep it secret, right? So it usually behooves you to keep your circle of people in the know small and make sure that they're all under contract to keep the trade secret secret. Then there are trademarks, and these can be lost through non-use in commerce. In other words, they can be abandoned. If you, let's say you happen to be a major auto manufacturer and you cease using a particular trademark in commerce, you no longer use it to indicate, to identify a car or something like that that you sell. After a period of time, it will be considered to be abandoned, and somebody else can pick up that trademark and go run with it because you no longer are using it. You have abandoned it. There are periodic maintenance fees required, and then there can also be cancellation. Trademarks can be lost through a cancellation proceeding. So let's talk about copyright strategy here. Here are some strategic considerations. One is your goal is to cover your idea with as many types of intellectual property as you practically can. This is going to be, among other things, it's going to be industry specific. Some types of industries, like any sort of commodity, may rely heavily on trademark. So if you're selling a new breakfast cereal, chances are most of the value of your trademark or your commodity is going to be in the trademark that you use to identify it. To a lesser degree, the trade secret, the recipe that you use to create it. But other people in the industry are going to probably figure out most of it. But basically, you're going to get, if you look at the margin on a particular good or service, most of that margin will probably be in your trademark and maybe to a lesser degree in a trade secret. Innovations rely heavily on patents. And I say rely heavily on, that doesn't mean that trademarks aren't important. And certain types of innovations like copyrights or like, let's say, computer code may rely heavily on patents and on copyrights. So keep that in mind. And creative arts lean heavily on copyright. So, and again, that's not exclusive. Let's say if you have a comic book series, that's going to be covered primarily by copyright, but there may also be some trademark considerations in there as well. So you need to figure out, what industry are you in? Is it mostly innovation in the sense of technological innovation, or is it mostly creative, or is it maybe a commodity that you feel like you have a better recipe for, or it meets a particular need? Let's say it's vegan, or particularly low in sugar or something like that. IP strategy is company specific. So just because you're playing in a certain industry doesn't mean that necessarily you're going to be a cookie cutter for one size fits all for everybody in your industry. There may be some aspects of your business that are very, very different from others. Just to take an example, if you were in the animated film industry, there may be some things, some processes that are behind what ends up being shown to a viewer that are very innovative from the computer standpoint. the computer is doing something that's unique, and that needs to be protected by patents, as well as obviously the copyrights and also the trademarks that are in that. So again, some companies rely heavily on patentable innovations. Some companies rely more on trade secrets to protect processes. You know, that's great. You can do that as long as your firewalls are strong and it's not easy to figure out what you're doing behind the scenes that differentiates you from others. And you should be aware, though, that if you're using a patentable process in kind of in a behind the scenes situation, you may actually run into something that's called the on sale bar. And you know, you need to talk with a patent professional before you make your decision. Oh, I'm going to hang my hat on trade secrets. Let's see. And I'm just going to say here, and this is almost always the case, that all companies need to consider trademarks. And, you know, you need to at least consider it. Now, how you come down and whether you're going to, you know, register your trademark or not, I'm not going to prejudge that, but you need to think about it. So let's talk about some fundamentals here. This is really fundamental. Keep good records. You want your intellectual property is mostly a thing of the mind, right? So this needs to be memorialized somehow. It's not like you know, the building that you own. And even with the building, you're going to want to keep, you know, a title deed or a lease or whatever. You're going to want to keep that well guarded. Well, in the same way that you want to keep the lease for your the title deed for your property well guarded, you know, preferably in a lock box off site in case there's a fire or something like that. But you want to keep good records of your intellectual property as well. And you want them documented and you want them organized and you want them centralized, but you also want to have maybe something decentralized, like some sort of redundancy, where you're able to recover things if you happen to have a disaster. These are all things that you want to make sure that you've got lined up before you know, this is part of your overall intellectual property strategy. You need to keep good records. And the kinds of records we're talking about are, you know, for copyright, copies of the things that you think are important that are copyrighted, some record of the date of creation. If they're published, some record of the date of publication. And if they're licensed from somebody else, then you want to have copies of the licenses. And you want to have, you know, sometimes licenses are a little complicated. They're like timelines and dates and milestones and things. And you want to have some sort of a way that, you know, you keep track of those things, you know, database of some sort. And you want to be able to articulate your strategy. Why? Well, investors want to know what your strategy is. Even if your strategy is, hey, we're just flying by the seat of our pants here, you better have a reason why you're okay with that. You know, oh, well, we don't need to worry about X. Fill in the blank there. And I've had people tell me, oh, we don't need to worry about that. And I'm like, well, really? You don't need to worry about that. Why do you say that? And then maybe they articulate a good reason for it. And I go, oh, okay, that makes sense. Or they don't really have an explanation. Well, that's not very good. You can have a slide deck. You can have a white paper. As I mentioned, you can have databases. You can have all sorts of ways to articulate it. But it's probably best if you can, you know, graph it out and show it to an investor. And just articulate what your strategy is. Let me talk for a minute about licenses versus assignment or work for hire. Whether you do something as a work for hire or not obviously has an impact on the term of copyrights. So if it, you know, the default is that, let's say I'm an independent contractor, I write something for you, let's say I write some code for you and I hand it over to you. I own the copyright and I'm giving you the license to use that. And we'll normally have some sort of a formalized agreement saying, I license you to use this, but I still own the copyright in the code. And I probably will go even farther and say what you can do with that code, are you limited to using it within your business, or are you allowed to maybe embed it in something else to maybe run a some sort of IoT type of device, Internet of Things type of device. So that's the normal way of doing these things. We'll call it normal or default, and that's the default period or term for that is the author's life plus 70 years. And remember that if there's more than one author involved, it's the last expiring author's life plus 70 years. So it might not be a bad idea to have a young collaborator if you want your copyright to last a really long time. Now, if it's a work for hire, on the other hand, it's 100 years from the date of creation. So that's a consideration here. Do you want it to, you might not, that's very important, but you may only care about the next 10 years or 20 years or something, but those 20 years come quick. I can tell you, I've been in the patent business for a while, and those 20 years they just fly by. And you put a lot of work and marketing money and whatnot into your idea, and it's here today and gone tomorrow. So you may think 70 author's life plus 70 years versus 100 years. If that author lives another 50 years, those last 20 years, and usually intellectual property, the most valuable part of the term of any intellectual property is toward the end of its life. This is true for patents almost always, that it takes time for innovation to work into the economy to the point where it becomes essential. And many times, now a lot of patents they're not valuable from the day that they're made because the technology grows beyond them very, very quickly, and they're, maybe 2 or 3, and maybe, they don't even pay the first maintenance fee, which is due at 4 years. But anything that makes it past the 12-year maintenance fee is probably really valuable, and you'd spend a lot of money to try to get another year or 2 out of that patent term. Well, so you want to think about it. This is true also in copyrights. You want to think hard about how you want to set that up from a term standpoint, but even more importantly, and maybe in some situations, might be the employment law impact. In California, for instance, and this is just a for instance, I don't know what the other states are, but I'm licensed in California, so I'm kind of up on this. California state law presumes that a work for hire is done by an employee. In fact, it's not even a rebuttable presumption. They just presume straight up, if it's a work for hire, this is an employee. Well, what does that mean for you as the employer? Well, it means you've got to comply with all the state's requirements for being an employer. And those requirements are pretty stiff in California. So maybe the best thing for you to do, again, talk with your patent professional or your copyright professional here. Maybe your best thing to do is to not, if you're not willing to go through the hassle of having that person as an employee, then you probably need to have them own the copyright and either license it or assign it to you or to the company. So that's what that says. Now, this is where it gets a little complicated. You might be able to put a choice of law clause in a contract so that's not under California law, maybe. But you need to be super you have to be careful about that, because if the contractor is living or working in California, a court might look at it and say, well, that's what the choice of law clause says, but we're not going to treat, we're going to strike that and we're going to apply our own law, especially if the court happens to be in California as well. So, again, these are things to consider, and I can't tell you what to do in every circumstance, but these are things you want to think about. Because, and then, my caveat that other states may vary. I don't know what they do in New York or in Maine. So, you have to pay attention to these things. So let's kind of compare copyright and trademark. They can overlap in some ways. And the biggest way that they might overlap is where you have a logo that's pretty creative. So it might meet the minimum creativity necessary for it to be covered by copyright. It might not, but it might. And well, you might think to yourself, well, I can, then I'll just use them interchangeably. They do serve different purposes, though, and so they have to be used differently. So a trademark, as you might recall, identifies a source of goods or source of services, whereas copyright protects original creations. So make sure that you use a trademark correctly to identify a source. And I used the example last week of, let's say, a T-shirt that has a label. And normally the label you will find in the little collar area in the back of the T-shirt, or you might see a little logo. You might see the little Lacoste alligator up here, or you might see a little polo guy, or I'm surely dating myself with these examples, but you get the idea. They indicate a source there, whereas if it's kind of emblazoned across the front, it might still be creative and it might be covered by copyright, but it's not really an indicator of source. And so you want to be careful, even if you have your trademark just emblazoned on your T-shirt, if you're selling T-shirts under that trademark, that you've got a label that identifies that source. Now, a lot of times companies will put their trademark on their clothing, right? Because they want to advertise. That's advertisement. It's not really use of the trademark in commerce. So you need to be careful about that. Now, and make sure that if it's copyrighted material, you actually put the little circle C there. So sometimes you will see, you will see a T-shirt with the logo of a company on there, and it might have both a trademark and a copyright notice on. So keep that in mind. Copyright versus trade secret. Pre-publication copyright and trade secret can coexist. And I said this before, that the copyrights are somewhat narrower than trade secrets because copyright requires that element of creativity, whereas a trade secret can just be a list of customer names or something like that. That can be a trade secret. So, in this example, we'd say, pre-publication, the term of copyright is still author's life plus 70 years or 100 years from date of creation, and trade secret is perpetual. So that's pre-publication. After publication, of course, the trade secret is no longer a trade secret. And, and I have this warning here that timing is everything. And, before you publish something, you want to make sure that you've filed a patent application for any patentable elements in there. So you see, it's kind of getting jumbled together here. It looks like Carrie thought that I was calling for her services. So it's one way to think about the term, or the way the term and the coverage of copyrights and patents is that the copyright is long and thin, whereas patent is short and broad. Now, again, they don't often cover the same thing. This is usually in the, when you're thinking about computer code and things like that. What I mean by that is copyright protection is long in that you get 70 years plus the author's life plus 70 years or 100 years from creation, whereas patent protection is only about 20 years. And it's a little bit more than that. But when you take out the time that it takes to get in, get through the patent office, it's never much more than 20 years. The copyright protection is thin because it covers only the creative elements, and you either need to have out and out copying or really bad effort at paraphrasing, generally. Patent protection is at least potentially broad in that it covers a lot more than just the disclosed article. If you ever look at a patent, you'll see that there's a drawing in there, but the patent isn't limited to that drawing. It's limited by the claims, which can be quite broad. And it can also cover through what's known as the doctrine of equivalence. It can cover a wider range of things than just what's literally claimed in the claims. Copyrights, of course, cover an original work of authorship. That means it covers things that have not been copied from others that have that minimal level of creativity in them. Whereas patents cover useful, novel, and non-obvious machines, manufacturers, processes, and compositions of matter. Copyright is created by fixing the original expression in a tangible medium, whereas patent must be examined by the USPTO. So copyright is really easy to create. It doesn't have a whole lot of breadth of coverage, but for what it does cover, it offers you a really long life, and it's really super easy to create it. Now you can also register it. There's an advantage to that, but it doesn't have to be registered. Patents have to be examined, and they have to be granted by the USPTO. Copyrights may be registered anytime after creation. Patents have to be filed, and they have to be examined, and they have to be filed before somebody else files on the same invention. Matter that's described in a patent can be copyrighted material. You want to watch out for fair use issues. And copyright doesn't cover, the idea that's expressed. And just keep in mind that disclosure in a patent doesn't negate the author's copyright in the same original work of authorship published in a journal article, for example. So a lot of times authors or patentees will be, let's say, academics working at a university, or maybe in collaboration with an academic at a university. And universities, of course, expect publication. Well, that publication is still covered by copyright, even if maybe pretty much equivalent subject matter is in a patent. And so that's something to keep in mind. So let me give you an example. We're talking about some computer code here. And the copyright here would protect the source code, the executable code, and that should be, and from out and out copying. Okay, so it protects the source code and the executable code from copying. And that's the term. And it protects the expressive elements in the executed code. So let's say the code actually, when executed, produces a graphical user interface, or a video, or a sound. So it protects all of those different levels of copyright there. And so the source code, let's say it's written in C++, and all of the syntax and everything that's in that C++ code. And then once it has been compiled into an executable form, it covers that as well. And then it also covers whatever the output is of the program. So that's pretty nice. Again, you get it for 70 plus years, but you pretty much have to have out and out copying or you know, a pretty, let's say a knowing, or pretty close to knowing, stealing or borrowing from that source code or executable code to violate the copyright. It doesn't actually cover the process that's programmed by the code. So somebody else could come along and independently write a very similar code, or no, let's not say it's very similar. Let's say it's very different. Maybe it's not written in C++, it's written in Pascal. I'll use a real old school example. And when it's compiled, the executable code is going to look different because it was compiled from a completely different source code. It may do essentially the same thing. It may take the same inputs and crank out the same outputs, but it's and as long as it's independently created, you know, as long as let's say these expressive elements end up being different enough, it would not, you know, so you could have you know, non-infringement at multiple levels here. Patents protect the process code, the process coded by the source code. So it's not dependent on whether it was written in C++ or whether it was written in Forth or Fortran or Lisp or, you know, whatever other possible, you know, the coding language it could be in. It actually protects basically the underlying algorithm, which is, you know, take A, add A to B, take C divided by D, you know, all those other things that go on within the code. It really doesn't matter how it's expressed. You still only get 20 years from filing in the US Patent Office. And the important thing here to keep in mind is, you know, one of the biggest caveats to patenting computer works is that they actually have to improve the way the computer itself works. And I'll show you a parallel to this in another example. But the way you want to think about this is it's not enough to take a process that human beings would normally do, like, you know, one that pops up a lot is, you know, some sort of a currency arbitrage or settlement type of program, and just do something that normally would be slow, but it can be done by humans, and speed it up by doing it on a computer. Just speeding something up by doing it on a computer isn't enough. It's got to go beyond that. It's got to actually speed up the way the computer works or improve the way the computer works. So you need to think about what's going on the back end and consider, you know, how that. Now, I'm not talking about design patents here, by the way. There can be considerable overlap in design patents. Kind of left that out of here, but that's another thing to consider. So like I said, taking a common business practice and doing it on a computer to speed it up, it's not enough, or to make it more convenient or whatever. Here's an example of, let's say, a printing process. The copyright would cover the individual expression in the printed object. Let's say you're printing, something, transfers for t-shirts. Again, you would get 70, you know, author's life plus 70 years from creation for the term, and it would protect the expressive elements in the printed object. So in this case would be the image that is, say, printed on t-shirts or something like that. But it does not cover the process by which the object was printed. So if there's any innovation in the way the transfers were made or the printing, you know, the printing was done, that would not be covered by copyright. And that may be okay. You may be using, you know, an old way of printing, or you may be using, you know, something that may be innovative, but somebody else has the patent and you're licensing it from them. And that's fine, you know, it's good to know those things. But if, let's say, you do some innovation in the way that you print the articles. Let's say you have some cool new way of 3D printing on cotton, and you would want to get a patent on that. And it doesn't matter, what the ultimate printed objects look like. It might for the patenting process, but in general, it wouldn't. And you get 20 years, and here's the thing. This is the parallel with the computer program. It has to improve the way that the prints are made. It can't just improve the prints themselves, although that might be a consideration to take into account when patenting the process. And most importantly, it doesn't cover the words or pictures in the printed article. So you might actually have both. You might have, some unique, very creative pictures that you've created, and then maybe you print them on, as prints or on T-shirts or something like that. And behind that, there might be a process that's been improved. And so you want to think about that. Now, maybe you only have one of these. Maybe you're not really in the printing business yourself. You just make machines that do printing. Well, copyright really wouldn't be your thing, would it? That would be more patenting. But maybe you do both. So you need to be able to, you need to have a strategy there. Here's another one. How about a how-to book or a video? So the copyright would protect the individual expression of the how-to book or video. Let's say it's how to put together a desk that you bought from a particular distributor from Sweden, and so you might watch a video on that, and that copyright wouldn't keep anybody else from making a video about that, but it would keep them from copying your video and selling it as their own. Again, that's the term. Again, it protects the expressive elements in the book or the video, but not the process itself that's being demonstrated. And but whereas a patent might protect the process described in the book or the video, say instead of putting together an existing article, maybe you're describing how to manufacture artificial silk by some novel process. It could cover that, right? It has to be novel, it has to be non-obvious, and it has to be patent eligible. And I talked about patent eligible, and it doesn't cover the words or the pictures in the book or the video per se. It covers that particular expression. So I hope this has been helpful. Again, if you have any questions, you can either email me at my email address down here, matt@ntiplaw.com, or you can call or text my phone number down here. So that's all I got for this week, Julie.
Well, thank you. That was a lot of information. So that was good. Thank you. And like Matt said, this is recorded. So if you have any questions, you can get back to Matt, or you can go to the City of Surprise Economic Development YouTube channel, and you can see the whole series. So if you've missed any of them, don't worry. They're all recorded and they're all on there. And we will see you back here next week talking about copyright diligence, correct?
Yep.
Great. Thank you very much.
All right. Have a good week.
You too.